Hi. Ooh, that was good. You got quiet very quickly. Thank you. I hope everyone's doing well. Let's see. Any questions? Anything in your minds? Anything on footnote 4 of Caroline Product? Oh, he's not here. Jorge emailed me the legislative history of the Filled Milk Act, and I actually read like 40 pages of it last night. So very good stuff. A couple fascinating parts. Several hearings were actually held about the federal Filled Milk Act, and apparently the companies that made filled milk were not invited, and they were even notified that they had to testify. So there was another hearing some months later where this guy from a company in Wisconsin said, "This is a subterfuge. This is a pretext for trying to destroy my industry." And the scientists, who were, they were respected doctors, their general argument was, if this filled milk is given to babies instead of regular milk, it won't be healthy for them. That was the general argument. And that was on that basis that the product was criminalized. You couldn't ship it interstate commerce. But it was perfectly lawful to eat within the state. There was actually another Supreme Court case in the 1920s which upheld, I think either Wisconsin or Ohio's ban on filled milk with a due process challenge. That case was actually cited in Caroline Products, but was edited out of your book. So I appreciate Jorge, who's not here, was giving me some extra reading material last night. So I'm grateful for that.
A few minutes late.
Okay, well, when he comes back, tell him I talked about it, okay? Favorably. So I'm very grateful when you send me stuff, I will read it. It's just if I've not seen it before. So I'll have to write about it. I even sent it to Charles Hauser's granddaughter. That was the owner of Caroline, and she was very excited to read it. So I respond. Okay, all these props not even here. Okay. What else? Anything else in your minds? No? All right, let's start. Our discussion today focuses on the Due Process Clause. And I've often described constitutional law not as a straight line, but as a series of curvy arcs going up and down. And what we saw in the early 20th century, about 1900 till 1930, if you want to approximate, is that courts were willing to look at the Due Process Clause and the liberty component as protecting certain unenumerated rights. It was primarily the liberty of contract, the right of contract. But as we see in Meyer v. Nebraska and Pierce v. Society of Sisters, it was not only about economic transactions, but also involved raising children, education, and other those sorts of things. But these liberty interests got in the way of various progressive laws. And with the decision in West Coast Hotel v. Parrish, the court signaled that we will no longer read the liberty clause, the liberty provision of the 14th Amendment, as a check on these sorts of progressive laws. Okay, but that wasn't the end of the story. We have Caroline Products and its famous footnote 4, the most cited footnote ever, which said, well, some liberty interests in the Constitution should be given some close scrutiny. If something is within the Bill of Rights, gets close scrutiny. If something affects a political process, we give it close scrutiny. If some law impacts the discrete and the insular minorities and the accessing of the political process, that will get some strict scrutiny. But with footnote 4 of Caroline Products, the notion of the court striking down laws that infringe on some nebulous notion of liberty was more or less a dead letter. And we saw that in a case yesterday or Tuesday called Williamson versus Lee Optical. And this was remember the eyeglass store, right? Can they criminalize the use of the lensometer, that little machine, by the opticians? And Justice Douglas basically said, look, we're not the Lochner court anymore. We're not in the business of looking at the word liberty and using that to enact a certain social theory that we believe in. And we won't look at that provision to invalidate various state laws that infringe on liberty. We'll simply defer to the police power, unless it falls within footnote 4, unless it's in the Bill of Rights, or there's a political process issue, or involves various discrete and insular minorities. So that was the law up to Williamson v. Lee Optical. But your book has a little excerpt. There are not many notes in your book, but actually I think it's pretty useful. The few pages before Griswold, which charts the trajectory. And starting in the 1960s, the court began to recognize that, well, remember we said don't look at the word liberty? We didn't really mean that, right? We didn't mean it like that. And the court began to recognize a general notion of privacy, which again is not listed anywhere in the Constitution, but they found it in various attributes of the Bill of Rights. You ever wonder why they say the penumbras and the emanations of the 14th Amendment and the Bill of Rights? They're trying to fit it into footnote 4. Right, footnote 4 said if it's within the Bill of Rights, we can give it strict scrutiny. This entire malarkey, right, about emanations and penumbras was about squeezing it into footnote 4. That's what they were doing. And that created this, what we now have, 2 tiers of rights. Rights that the court likes, which it calls fundamental, are given this sort of strict scrutiny or something higher. Other rights, which the court does not particularly care for, are given the rational basis Ash-heap review. Why are some rights in this top tier and other rights in this bottom tier? The court's never done a particularly good job explaining this. With equal protection, I can give you a reason why some classifications are suspect and others not. Race, for example, is immutable, right? Can't change it. So there's a pretty good reason why race is in the top tier. We've discussed gender. Maybe there are reasons why gender should be treated differently. So maybe that's in the middle tier. And, you know, economic status, for example, mental handicaps, those are not immutable factors. You can maybe change them. So those are in the bottom tier. I can give you reasons why equal protection sliced up the way it is. Maybe we agree with it. Maybe we disagree with it. But there's, you know, I can give you some reasons. But when it comes to the due process clause and this breakdown of tiers, fundamental rights versus non-fundamental rights, there's not a particularly good reason other than the fact that justices like privacy, but they don't particularly care about economic rights. And that's it in a nutshell. So you see in the Griswold decision, which we'll end class today, Justice Douglas is at war with himself, saying, look, please, this is not locked in. Believe me, this is not locked in. We're doing something else. This is footnote 4. We're fine. We're good. We're cool, right? He's not fooling anyone. But once they made that pivot in Griswold, they simply can keep citing Griswold for the proposition that rights affecting privacy get this heightened review. Right? They bit the bullet in Griswold and they just ran on from there. Right? After that, they don't need to defend. No, we're not doing Locke, we're doing Griswold. But the Griswold decision is the least offensive of them all. And we'll get to that later today. We'll discuss this, but as Justice Stewart noted in his dissent, it's an uncommonly silly law that was frankly never enforced. And Griswold has basically begged to be arrested so she could challenge this in court. Right? This was not a law that anyone actually enforced. Okay? But I want to go back and start our class today, if I may, with the 1920s, the raging Lochner era, so to speak, with 2 cases that are considered the pillar stones of substantive due process, the idea that the Liberty Clause of the 14th Amendment gives courts the license to strike laws down. And what I want you to keep in mind in both Meyer and Pierce is how the court construes these rights. Note, they're not about a First Amendment right of religion. They're not about a First Amendment right of association. They're not about a First Amendment right of speech. If you read Griswold, Doug was like, oh yeah, Meyer and Pierce were First Amendment cases. No, they were not. Justice Kennedy's made a similar point in recent years. They weren't. They were Lochner era cases. Justice Black at least has the honesty to admit that in his Griswold dissent. But Meyer and Pierce were, again, written by who? Justice McReynolds, right? One of the same horsemen who dissented in the West Coast Hotel case. Also, he was a raging anti-Semite. But at least here he recognized a liberty interest at stake. Any questions about that general concept? The general trajectory of how the Due Process Clause waved throughout the 20th century? No? All right, let's do Meyer. I don't have pictures of Meyer, I'm sorry. I've been to Nebraska. I went to the state capitol. I don't think I have any pictures up there. Where did I finish off? Who is next? Come on. Oh, what are you writing at? Did I do my first vaunted row? If I skip a review, you guys will lynch me. Jason! All right, give me the facts of Meyer, and then don't worry. I will not skip them again. Even in my proper, I was like, do I call on you guys? I want to make sure I'm not skipping them there also. Go ahead, Jason. What are the facts of Meyer?
In Meyer, we're looking at a Nebraska law against teaching a foreign language to a student that hasn't quite graduated 8th grade yet. So roughly, I think they said 12 years old. And there was a teacher who taught an 8-year-old German, and then that's why we've kind of why we've gotten here. I kind of got the impression that this is another one of those, anti-immigrant sort of.
Yes. Oh, you stole my next question. Don't worry, you got a question coming up. Don't worry. Yeah, I mean, why would you say this is 1923? They're arresting a teacher for teaching German of a language. What do you think is
we're in the World War era. So.
Yeah. So again, anti-immigrant sentiments is nothing new, right? We've been here before. In World War I, there was a very, very strong anti-German animus, as well as in World War II. Not quite as strong as the anti-Japanese animus, but it was pretty well pronounced. I only know this. I have a dachshund, right? And they would actually kill dachshunds because of German dogs, right? The phrase sauerkraut was eliminated instead of freedom cabbage, right? Well, freedom fries came later. That was during the Iraq conflict when France was being difficult. But the during
I thought it was Liberty
Cabbage. Was it Freedom Cabbage or Liberty Cabbage?
I've been told it was Liberty Cabbage. It could have been both.
Well, I think I may have heard the other one, but you quite possibly are right. I'm dating myself a bit, perhaps. But this was part of an anti-German sentiment. Now, on the face of the statute, right? The face of the statute said you can't teach a foreign language, period, right? But Brian, were there any exemptions put into this law by judicial construction?
I believe so.
Could you teach any foreign language to these kids?
You can teach dead languages.
Yeah, what the hell's a dead language?
Latin.
Greek, right? Dead. Hebrew isn't quite dead, but I get the gist. Yeah, so here we have a statute that very clearly was designed to punish the teaching of immigrant languages. Italian, German. It was primarily German. That's where the case rose, but Italian, Spanish, French, right? Non-Anglo-Saxon. I guess not Anglo-Saxon is German, but the non English languages, basically, right? And this law affected not only the teaching, right, but also affected students, and it also affected parents, right? When you pass a law saying a student can't be taught X, okay, that puts the teacher in doubt. That puts the student in doubt because he can't learn what he wants to obtain knowledge on. And the parent says, I want my son to learn German. So it's infringing in 3 ways the various rights.
Just kind of follow-up question with this. The international schools, I'm curious, during this time period.
I don't think there were any in Nebraska at this time.
Oh, okay. Oh,
if I had to guess,
in 1920s, yeah.
If I had to guess, in 1920 Nebraska, they were not international schools. If I'm wrong, please correct me. Corey's not here, but I'm sure someone can fact check me. But I'm pretty sure I'm on solid ground here.
I was just curious if they would shut those.
Right. So, how many of you heard of the Scopes monkey trial? Right, where a teacher was punished for teaching evolution.
Yeah.
Anyone ever heard of this case? No. Why not? Why not? I mean, you basically have the same thing. A teacher is criminalized for teaching something, and it's not like evolution, which was a contestable theory. This is a language. Think about why this case perhaps wasn't as popular. I was going to answer, but you want to go for it?
Oh, I was just going to say we probably wouldn't hear about it because at this point it would seem ludicrous. Whereas there's still a sizable number of people who would say that it's not a good idea to teach evolution in schools.
Okay. So we have here this case, right? Where by the way, it's a private school. It's not a public school. It's a Lutheran school, and they pass this law. So, Alex, did the court mention the First Amendment right of free speech in this case?
No,
Did they mention the First Amendment right of free exercise?
no,
Did they mention the Equal Protection Clause? Maybe this is being racist against Germans.
no.
What was the basis of the decision in Meyer?
The right of association. I think that's where it's,
Well, but that's in the First Amendment. Is a free association? Is that what they're relying on?
I mean, what I got from it was what you said about the teachers and students, that it infringes upon their rights to like the teacher to teach and the student.
But what right are they asserting?
Like an individual personal right that's not in the right of specific.
So where do we get it from in the Constitution?
We don't. It's construed from it.
From which provision?
Liberty.
In which amendment? You're almost there. You're almost done. There's only one possible amendment. Come on.
Life, the
Oh, come on.
14th.
14, thank you. The Due Process Clause, yes. The entire basis of this case is the word liberty in the 14th Amendment, which says that a state shall not deprive a person of life, liberty, or property without due process of law. So how do we give meaning? How do we give substance to the word liberty, right? This is the idea of substantive due process, the meaning of the word liberty. The Lochner case described liberty in terms of a freedom of contract and the right to make financial arrangements in your business. But here, the court tries to define liberty not simply with respect to contractual matters, but also familial matters. So Carissa, how does the court here, Carissa, define liberty in the 14th Amendment? How does Joseph McReynolds tell us what liberty is?
Well, liberty is like business, like throughout the past century to try and determine, like, I mean not determine, but like saying that liberty is like it's like freedom from bodily restraint.
Is it merely freedom from bodily restraint? Is that the extent of liberty?
It's not the extent, but like they try to stretch it beyond that.
Ah, okay. So how do they stretch it beyond physical bodily restraint, Carissa?
They like try to define it broadly.
Okay, what does McReynolds say? What does he say liberty is? He gives examples.
He says that it's not just like merely like body restraint, but also right individuals to contract, engage like in like the pursuits of life and
Keep going.
acquire like knowledge and marry and children, worship God, and generally enjoy these privileges. They're recognized by common law.
Yeah, so he gives us a list, right? And Chris has said several of them. It's the right to contract, to engage in any common occupation, to acquire useful knowledge, to marry, to establish a home and bring up children, to worship God according to the dictates of his own conscience, and generally to enjoy those privileges long recognized in common law as essential to the orderly pursuit of happiness by free men. Jens, where the heck does he get this from? Where is he getting this from? I don't see a citation. Do you?
No, I do not.
Where does he get this from? Mike, I don't know where he's getting
I think some of it will. Some of it comes from previous cases, or well, let me see.
Well, Lochner was about contract and occupation. Where's this stuff about establishing a home and marrying and raising a family? Where acquiring useful knowledge? I mean, this sounds great, but where the hell is he getting it from?
He's not getting. He's getting it from his own, like from his own personal beliefs.
Is he?
I don't think so.
What does he say in the very last sentence? The very last part of that list. Generally, what does he say?
Pursuit of happiness by free men.
No. Read the entire thing. Generally to enjoy. Kill me. Generally to enjoy those privileges long recognized at common law as essential to the orderly pursuit of happiness by free men. Jens, what's he getting at there? Where is he deriving these postulates from, these premises from?
I think it's common law. You can even say like it's English common law. You go back.
Okay, Jason, want to take a step?
Civil rights.
How do we know these are civil rights?
it's a list just like they had a list in the Civil Rights Act about voting and.
Hadn't been enacted yet. Oh, 1866?
Mhm.
I don't know if that's stuff about family and learning in there.
Oh.
Some of the stuff is overlapping. Andrew, where the hell is he getting these rights from? How does he know these are the rights long pursued by men at common law? Where do we know this from?
So wouldn't it be stretching back to English common law, like what came after? I guess like.
Where did it say Magna Carta, the right to raise children? I read Magna Carta. It's not in there. I'll take my word for it, right? But where's he getting? There's no citation. Where's he getting this from? Yeah, Mara?
Aren't those kind of the reasons why, like, America started in the first place?
Okay, give me more.
So, like, they, like, in England, they were, like, trying to control all of these matters, like, according to, like, the rules of the king. So, in order to, like, live in a more free manner, they came and started.
Huh. Vanna, you want to add something? Where is Justice McReynolds getting this list from? It's a very specific list. You know, these aren't random. They're very specific things that's put in this list.
I mean, is it part of like a list they made when they first separated?
Well, I've never seen this list. If there's this list, you can guys maybe Sergio can fact check me, right? But I don't know what this list is. All right, where the hell is he getting this from? Made it up. You just pull these out of whole cloth. Thin air. Pull that thin air.
Well, like 25 people have been asked the question and this is different, and they didn't know where it came from.
So you know what I'm doing, right? You know I'm asking all these people. See, he's on to me. The reason I'm asking people is to illustrate a point. If these 8 or 9 people can't give me an answer, how's he giving me an answer? They want to see the diary figuring me out. Good job, yeah. Right? This is like with the lottery. I'm like, who wants a guy to get stoned? Yes, stone him. So okay, here we have a little diversity of thought. Good. So if you know these 8 smart law students, right, can't come up with this conclusion, how the hell do we know that this right to establish a home, marry is what liberty means? How do we know what liberty means, Ken?
I guess those are accepted, but he's kind of broadening the meaning on his own terms.
Yeah. So look, right. So let's be candid here, right? And I don't mean this necessarily in a critical way, but when a judge starts using the word liberty to mean stuff, he has to do something, right? It can't. He says it's not only bodily restraint; it actually means some sort of substantive right. And which rights the court reads into the word liberty is a very tricky function. Because who's to say that marriage should be in this list? The idea of state-run marriage is actually a fairly recent invention. Historically, marriage was something you did with religious ceremony. It wasn't something you'd have, right? It's a fairly novel invention. Bringing up children, acquiring useful knowledge. I mean, that sounds nice. Sparta didn't let you bring up your kids, right? You read that in the thing. Sparta, they took your kids to paddocks when they were 7 and raised them to be warriors. Right? Anyone want to weigh in on this? This is not. I don't mean this in a cynical fashion, because he may not necessarily be wrong, right? Perhaps he says that these indeed are rights that have long been enjoyed at common law. Maybe he's right, but you have to be cognizant of where these things come from. Yeah, Stephen.
Well, wouldn't it be like general notions of happiness?
General notions of happiness. Tell me what that means, sir.
Well, in my opinion, it's like general notion of happiness is just kind of like daily life. Like you have to recognize what liberty interests. So, like if I'm gonna live my life to the fullest, like I want to make sure that things that are important to be protected. So
You just kept saying me, my, right?
That's how I do it, right?
Yeah. Right, but see, McReynolds isn't making ruling for himself. He's making rule for millions of people. Heather.
Well, it seems like some people think like what liberty means is the government just leaving us all alone and letting us, something that, but then what Stephen kind of said and what last class we kind of said was there's also the thought when the government's taking care of everything, then you have the freedom to not worry about things. So then that's the liberty too. So it's like,
Anyone else hasn't spoken yet, maybe? No, quiet. All right, fine.
Isn't it an opportunity for the court to like expand their legislative arm?
The course legislative arm. My God, what the hell is that?
Well, it's the
Where's this legislative arm? I can't
well,
say
it's
what
going like all the way back to Supreme Court decisions are the supreme law of the land.
Oh, who the hell said that? They hadn't said that yet. This was before.
Oh, okay.
Or actually, yeah, no, they haven't said that yet.
Oh,
Alex, the Supreme Court has no legislative arm, thank God. They don't have the Supreme Court does not have a branch where they write bills and they propose to Congress. Thankfully, they don't do that. Sometimes they actually do. You actually see opinions sometimes where they propose alternate ways of writing a statute and say, maybe try this. Alex.
Well, in one of these cases, I can't remember which one, that cites to Meyer, it says that he did that to because the founding fathers, when they wrote the Constitution, didn't want people to construe the fact that some rights were in there and could harm other rights that aren't in there, and vice versa.
That was Justice Goldberg and Griswold by the Ninth Amendment, right?
So, yeah.
I was just going to say that, I mean, if he's not pulling this from some specific thing that's written down,
Sorry.
that he's kind of getting these broad stroke ideas from just what was the norm in society at the time.
Okay. Now we're actually getting somewhere, right? So he's not, and I perhaps spoke too crudely, but he's not pulling these out of thin air, right? He's reaching for stuff that, had you taken a poll in 1923 of the top 5 most important things, right? Raising a family would probably be on there. Worshiping God would probably be on that list. Learning, probably on that list. Having a living for your family, that probably on the top 5. So he's looking at rights, and I think the key word, I was bothering Jens about this a few minutes ago, but those privileges long recognized. And I think that's the key phrase here, that these are not things that are fictional, that have come out of thin air. These are rights that are long recognized, that people have long understood to be part of our society. And I think Stephen was getting there, was like, yeah, these are things that are really important to me. And I wasn't picking on him, but if you'd taken a poll of everyone in the class, people have different orderings of how you put your top 10, but top 10s are probably about the same. Maybe the ordering's different, but he's getting, I think, look, these are things which everyone would agree are important. So the word liberty for him is not only what was liberty in 1868 when the 14th Amendment was ratified, but it was these long-standing, deeply rooted traditions, these deeply rooted traditions that we have. And I think that's what McReynolds is getting at. Right? And I'm almost there. And where the key point is in that same paragraph, he says, the determination by the legislature of what constitutes a proper exercise of the police power is not final, but is subject to supervision by the courts. The idea is that if the legislature doesn't recognize these long-standing traditions, that is where it's okay for the judges to intervene. And think about this in terms of Lochner, right? The idea of limiting hours was a novel idea. This was a progressive idea that had never been done before, right? This was a new thing. So that Lochner court said, you are interfering with a long-standing norm that I can set the terms of my own work hours. In this case, the government had never before told a teacher what languages he can or cannot teach. Parents had always had the prerogative of directing the upbringing of their children. So as a result, this law interferes with these long-standing traditions. And that's why the court, I think, is comfortable enough in striking it down. Right? The German teacher wasn't asking for the recognition of some new highfalutin right that had never been recognized. They were asking for protection of something that had always been done. This law changed the status quo, right? This law added a new thing that the state can now control education. That was new. There have been compulsory education laws, so those weren't suspect, right? But this was the new wrinkle. You got to teach them this way. I mean, now we have Common Core about telling everything teachers have to do, but back then that wasn't a thing. This was new. That the state had any role in education. Nathan, patiently waiting.
So was McReynolds a progressive judge?
Absolutely not.
No. So
No.
Did he not realize that maybe by him defining his own definition of liberty, he left the door open for future justices to
Good
completely
question.
redefine it?
So do you think that's what he thought? Do you think he thought that would happen? Oh, you shake your head yes, you shake your head no.
Well, if you say he was not.
He's
progressive,
conservative as they come.
I don't think so.
So I think, your question is well taken. I think the response that McReynolds would give you is that the rights that courts protect are those that are deeply rooted. And for a right to achieve that level of acceptance takes time. And it would not open the door to all these newfangled rights that are hitherto unknown, right? There's a case that's not in your book, and it's not good law anymore, so I can't assign it, called Washington versus Glucksberg. And that case involved what's called assisted suicide. Do you know what this is? Whether you have some states have passed laws saying that if you have a person who's maybe terminally ill, can a physician, a licensed physician, administer some drug to painlessly kill the person, put him out of suffering, however you want to phrase it, right? So if a state wants to grant this sort of liberty interest to people to have assisted suicide, they can do it. But what if a state does not? So what happened was some doctors in Washington filed suit and challenged the constitutionality of the state's suicide law, saying you need to let me assist this guy with a suicide. The court, I think it was 5-4, ruled against the doctor. And they said this assisted suicide is not a deeply rooted right. This is some new thing, right? This is not defined anywhere. Maybe a couple countries in the world had it. This is not deeply rooted. So if there's a period of time where the court suggested that the sorts of substantive due process rights that will be protected are those that are traditional. I think it goes back to McReynolds and Myers. The reason why I don't assign Washington versus Glucksberg is that Obergefell, the same-sex marriage decision, overruled it. And there's not exactly, but it pretty much did. You'll see it when you read the decision. There's this one passage in Justice Kennedy's opinion where he says, well, you know, if we were to limit liberty interests to those that are deeply rooted, that would not include gay marriage because it's a fairly novel idea. Therefore, we're overruling Washington v. Glucksberg. You'll see it. You'll get there. I don't want to spoil the surprise. But basically, they says, yeah, if we follow Glucksberg, the gay marriage law has to survive, so we're going to do something else. But McReynolds, I think the core of his recognition, this is perhaps a Nathan's well-put question, is that only those rights that are long recognized. I think that's the key aspect. But yeah, you're absolutely right. I mean, the decision for McReynolds here paved the way for Griswold in ways that he probably did not anticipate. So question on that aspect, we're on one sentence of the case, that's the most important sentence. Everything else after this is pretty easy. Once you get over that hump of how you define the liberty interest, the rest of the case follows. So it's like a normal opinion. But that one sentence, that very first sentence, it denotes not merely freedom, right? That sentence is like the crux of the entire decade. All right, so Brett, now that we know that we can define liberty to include establishing homes and bringing up children, where do we know? What do we know about education, right? Why is education such a liberty interest? How do we know this? What does he say?
Because it's the parents' right to bring up their children.
Ah.
Basically interfering with parents' right of decision making with educating the children, puts the legislature into the home.
Yeah. And I'll make this more precise. He actually splits it up to three separate interests. First, that education itself, that is acquiring education, is a liberty interest. Second, there's the parent's duty, that as the parent can control how his children obtains education. And third, there's actually the liberty interest of the teacher, the right of the teacher to earn an honest living. Right? Because by throwing this teacher in jail, right? By throwing this teacher in jail, you're basically saying that he can't, pursue an honest occupation. And again, Lochner was good law at this point, right? Various restrictions on state employment were upheld. This law, the court says, affects all three liberty interests: the power to obtain language, the power to acquire knowledge, and the power of parents to control the education of their children. The court says that the police power goes far, but not far enough, and that this is an unreasonable restriction. or to put it in technical terms, no process could ever justify this deprivation of liberty, right? This liberty interest is so severe, so strong, that this law is completely arbitrary. It doesn't even come close to justifying this deprivation. And this is one of the things people often miss about due process. It says you can be deprived of this liberty if given due process. But if some law is so arbitrary, so unreasonable, no amount of process can save it. No trial can save it, right? This guy was convicted before a jury, but no process can save a law this unreasonable. Right? He says no emergency requires a child to learn English. He says, sure, it's important for kids to learn English, but not in this fashion. It's arbitrary without reasonable relation to any ends. The means do not justify the ends. Okay, any question in the majority opinion? Any questions in the majority opinion? So there's a dissent. It's not in your book, and it's in fact not in this case. But this was what's called a companion case, where there were 3 or 4 decisions raising the same issue. There were cases also from Iowa and Ohio. And guess who wrote dissent? Your favorite Justice Holmes, Mr. Lottery, right? He would have upheld this statute. He says, and again, I didn't assign it, so I can't ask you about it, but I'll read parts of it for you. He says it's certainly desirable that all citizens speak a common language and a common tongue. And therefore, the statute is achieving an end that is both lawful and proper. Right? He says this is a reasonable method, this criminal statute, of reaching that result. And he actually goes back and cites a number of the Lochner-era cases, saying that it's not for the courts to second guess how the state designs its police power. Reasonable men might differ on this question. This is his Lochner dissent. We are not here as judges to implement a specific social theory. He would allow the states to engage in experiments. He says, I am unable to say that the Constitution prevents experiments being tried. This is a notion made famous by Justice Brandeis, the idea that states were laboratories of democracy, that by allowing each state to do different things, they could experiment. People today think, oh, wow, they were Federalists. No, they weren't Federalists. The entire notion of the laboratory of democracy was to let states enact these progressive laws that infringe on various liberty interests, right? He wasn't saying let the states deregulate, right? That's the opposite. It's let the states do more progressive laws. But with that, the court struck down by a vote of 7-2. 7-2, it wasn't 5-4, 7-2. The German, the language law. Okay, any questions on Meyer? Any questions on Meyer? Yeah.
I feel like it was also a very heavy religious ordinance too.
Very real. I'm sorry.
Religious ordinance too. Language also, promoting Judeo-Christian. The languages.
Not Judeo. Hebrews. I guess Hebrews allows it as a dead language, but
I'm being courteous.
Yeah. 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 I mean, what if you go to a Greek Orthodox church, right? Exactly. What if you go to a German Lutheran church, right?
Or just so even if you have a mass that includes it.
Well, dead languages are okay. Latin's good.
Right.
Yeah.
That's what I mean. It's Christian.
Yeah. There's definitely a religious component here, and I think the court is acknowledging the anti-immigrant backing. The next case is big league, right? It's big league anti-religious. So let's talk. Yeah, Patrick. Let's talk about Pierce v. Society of Sisters.
So, state of Oregon passed an ordinance saying that children between the ages of 8 to 16 had to attend public school. And after this happened, there was this religious organization, Catholic corporation, that taught students in this age range, and parents started pulling their kids out of their school and to abide by the state ordinance. And so, with the economic effect of a lawsuit,
Yeah. Yeah. So this case decided in 1925 was more or less a follow-up to Pierce. I'm sorry, Meyer. You may not think much about it, but in the early 20th century, the idea of a public school is somewhat novel. Most schools were privately run. That was simply the case. You had religious schools, you had a military academy, one of the schools at issue, but these were privately run institutions. Another strand of racism that you may not even be familiar with is anti-Catholicism. It was very, very, very strong in up until maybe the 1960s. People thought that John Kennedy would be an agent for the Pope. It's true. Google it. It's true. This law, which basically said you had to send your kids to public school, was expressly designed to shut down Catholic schools. There's not much about it. These laws were backed by the Ku Klux Klan and others. The idea was we want people in public schools to be American. We don't want them to be Roman Catholic. These were assimilation measures. The language statute, the schooling statute, these were the same piece. They were assimilation measures. And they were designed to shut down Catholic schools. Relatedly, you have these laws called Blaine Amendments, sponsored by a senator from Maine, I think, named Blaine, that says, oh, the state can't fund religion, right? The state can't give money to religious groups. This wasn't about Establishment Clause jurisprudence. This is about depriving Roman Catholic schools of money. So lots of these laws, which seem to be about neutrality to religion, were actually designed as punishment of Catholic schools. So as a result, if you have to send your kid to a public school, the Catholic schools started losing money and they started shutting down. And parents started yanking their kids out of these schools. So one such organization, the Society of Sisters, which is a group of nuns, brought a lawsuit challenging the constitutionality of this statute. Now, I want to pause briefly on this note. In Meyer, right, whose right were we talking about? It was the right of the teacher, the kids, and the parents, right? But here, there's another group floating around. This suit was brought by the corporation, the school. And the school is asserting that because of this law, they were losing money. Right? How can a corporation assert the rights of their students and the parents of those students, right? This lawsuit was not brought by parents. It was brought by the corporation itself. I mentioned this ever so briefly to alert you that the idea that corporations have constitutional rights is not new, my friends. This principle's been around for a very long time. So next time you hear someone scream saying, corporations don't have rights, you go say Pierce. It's a 90-year-old case. Indeed, corporations can invoke standing on behalf of those they're associated with, whether it's their students or the parents of students or others. Right? The corporation itself, of course, has no rights in its own course, but it associates with those who do. In the same fashion, Citizens United has no rights, but the producers and movie directors they associate with do have those rights. So the suit was brought by the Society of Sisters, a group of nuns, and by the Hill Military Academy, which was a private school shut down. And again, this was not a First Amendment speech case. This was not a First Amendment religion case. At the time, neither provision had been incorporated or sent to the states. Rather, Georgina, what provision was this law challenged under? Exactly. Which provision of the 14th Amendment? Exactly. Okay, so how does the court go on to extend Meyer in this case? What's their analysis? Perfect. Right. Exactly right. The court basically says this is no different than Meyer v. Nebraska. Right. This is no different than Meyer against Nebraska. Parents have the right to direct the upbringing of their children, and by forcing them to go to this public school, you are infringing on that right. So under the principle Meyer, the Oregon statute was unconstitutional. I mean, this is why Meyer and Pierce are like two sides of the same coin. They're very closely related. All right, not much more to add in that case. It's more or less a do-over. Any questions on Pierce or Myers? Yes.
So basically, Pierce was just a reiteration of mine.
Yeah, and with the wrinkle that this applies to corporations as well. Heather?
It seems like there's a pendulum, and sometimes states are really against like homeschooling and stuff. Do you think that that's pretty much safe? I mean, parents' rights to educate.
Well, in litigation over homeschooling, this is a case that's often cited. But if you notice, neither Meyer nor Pierce challenged the notion that compulsory education laws are valid. So you can have compulsory education laws, but if parents choose to do it at home, it meets a certain level, that's permitted. Here, it's basically saying you have to go to public school, period.
Right.
But let me take Heather's question. What if Meyer went the other way and Pierce went the other way? Could a state ban homeschooling? Right? And a state could choose to allow homeschooling, but the Constitution would not prohibit them from doing so. I think a lot of states probably would ban homeschooling. You're shaking. Do you have homeschool kids?
I
Or
did, yeah, I did.
is Texas good with that stuff?
Oh yeah, Texas is super easy. Some states you have to like give lesson plan, turn in lesson plan and stuff, but Texas.
Yeah.
I was just curious with Meyer, does that come up at all today? I mean, being from Texas, there's kind of the, I guess, there's the general kind of redneck, like, if you don't speak English, you can get out kind of thing going on.
Not to generalize or anything, right?
Does this come up at all?
I don't know if any
Teaching
state.
Spanish?
I don't think so. See?
When I was in high school, they were
Well, bullies, yeah. Yeah. I think the extent of Meyer, and to the extent that's relevant, is that they can't throw you in jail for teaching a foreign language.
Okay.
I don't think they say whether or not you have to teach English. Vince?
I would say, what about like, English as a second language? Because like we're talking about not.
Yeah, that's not implicated here. It's what you can teach is fine, but here it's criminalizing what you can't teach. Anything else on Meyer or Pierce? All right, let's move on. Got a lot to cover today. The next case is probably one of the hardest cases of the semester to teach, and it's probably one of the hardest cases of the semester to read. You were probably all struck by how short it was, right? Because usually you say, "Oh man, I download this long supplement." No, it was it 2 pages, right? It's not in your book. It will be in the 3rd edition. So I will insist on that. It's a short case, but it's an important one. And the reason why this case, I think, is so difficult is because of how jarring Justice Holmes's prose is. Separate from how you actually think of the due process issue, the wording is so cold. I am not a Holmes fan, so I won't try and defend him, but I will try. This was a man who said, if my fellow citizens want to go to hell, I'll help them get here. And remember when I talked about the lottery, I said that Justice Holmes would probably be in favor of the lottery? Yeah. It was pretty much a random lottery of who to stone, who to sterilize. So I think he would be okay with that. He dissented in virtually every single substantive due process case there was. So let me tell you about this case. We often think of Sergio sent me something else that was good. You know what to do? Yeah. So we often think of the idea of eugenics as a Nazi enterprise. It's certainly the case that the Nazis perfected the idea of eugenics, but it was invented in the United States. And the most learned men of society in the early 1900s, the presidents of Harvard and Michigan, these other big schools, were eugenicists. So I'm going to play a clip from this movie in 1961, which Sergio sent me a couple days ago, called Judgment at Nuremberg. And the Nuremberg trials were held following the conclusion of the Second World War to prosecute the various Nazis. In fact, the lead prosecutor was Robert Jackson. But one of the leading crimes that were prosecuting was the crime of eugenics. and the idea of using this racial science to basically cleanse the race of undesirables. Jews, Romans, Gypsies, others, right? So I want to play this clip for you. It's 2 minutes.
Dr. Wick, you referred to novel National Socialist measures introduced, among them sexual sterilization. Are you aware that sexual sterilization was not invented by National Socialism, but had been advanced for years before as a weapon in dealing with the mentally incompetent and the criminal?
Yes, I'm aware of that.
Are you aware that it has advocates among leading citizens in many other countries?
I'm not an expert on such laws.
Permit me to read one to you. This is a High Court opinion upholding such laws in existence in another country.
I'll summarize if you can hear it later.
I quote, "We have seen more than once that the public welfare may call upon the best citizens for their lives. It would be strange, indeed, if it could not call upon those who already sapped the strength of the state for these lesser sacrifices in order to prevent our being swamped by incompetence. It is better for all the world if, instead of waiting to execute degenerate offsprings for crime or to let them starve for their imbecility, society can prevent their propagation by medical means in the first place. 3 generations of imbeciles are enough." You recognize it now, Dr. Wick?
No, sir, I don't.
Actually, there is no particular reason you should, since the opinion upholds the sterilization law in the state of Virginia, of the United States, and was written and delivered by that great American jurist, Supreme Court Justice Oliver Wendell Holmes.
So for those who couldn't hear it, I apologize. I never know quite how loud it'll sound in the classroom. There was a witness testifying about eugenics, trying to say this was a Nazi project. And the lawyer, who was a lawyer for the Germans, said, "I'm going to read an opinion from a high court decision," doesn't say which one. And he reads from the Holmes opinion. And he gets the bit about, the 3 generations of imbeciles are enough. And he goes to the witness, "Do you know where this is from?" He's like, "I don't know." He's like, "Oliver Wendell Holmes." So Holmes was actually cited by the Nazis in defense of their program. Right, this is why I can't defend the guy, right? I've tried, but I think he's the most overrated justice ever after John Marshall. It's a close second, but he's up there. I want to walk you through the history of this case because it's even more troubling. As bad as Holmes's opinion was, it was even worse because he lied about the facts. And it's not that he was lying, but he recited facts that were given to him by the government. So I mentioned, I think when we did the Loving case, the Racial Purity Act of 1924. Remember I mentioned that? I have to flag it. The same law that criminalized in Virginia interracial marriage also imposed this eugenics regime. This was one of the same measure to rid the race of undesirables. And it wasn't just interracial people. It was also people deemed undesirable. So in the early 20th century, Virginia was at the vanguard of this sort of movement to use the power of the state to get rid of undesirables. So here's Carrie Buck. Carrie Buck was designated as feeble-minded. And she was charged with promiscuity. Why was she deemed feeble-minded? Does anyone know? Yeah? Oh, no, it's even worse. Anyone know the answer? How did she have a child out of wedlock? Raped. She was, her mother was a single mom, and she gave her up for adoption to an uncle. And she was basically living with the uncle as a quasi-servant, right? She was basically forced to do household chores. And the uncle raped her, and she got pregnant. And then rather than acknowledge the fact that the uncle, raped his niece, they told the police that she was imbecile and that she was feeble-minded and promiscuous. So they sent her off to the colony for imbeciles. I have a picture of it somewhere. This is her mother, Carrie. this is Dr. Bell, who was the head of the Virginia Colony for Epileptics. And they hadn't yet actually carried out, no pun intended, one of these sterilizations. And they were unsure if it was going to be upheld in court. So they wanted a test case. They wanted a test case to go all the way to the Supreme Court to get a blessing from the Supreme Court, because the Supreme Court upheld this and all the other states could then follow suit. So this was Dr. Bell who ran the clinic. This was the courthouse, and this is the colony for epileptics and feeble-minded. So a couple things about this case. It's not even clear if Carrie Buck understood what was going on. She was indeed given a lawyer under the statute. The lawyer worked for the colony. So you want to talk about a conflict of interest, right? The lawyer wanted this case to go up to the Supreme Court. But the reason why this case was viewed as such a potent case, assert the idea of imbecility being genetic. And they found the perfect case. Now, Holmes says in his opinion, 3 generations of imbeciles are enough. And it's a very cold line. But if you actually realize why he says that, it gets even worse. This is Carrie Buck's family tree. If you read it, you can say, most immediate blood kin of Carrie Buck, showing illegitimacy and hereditary feeble-mindedness. And I want you to look at these tiers, right? Tier 1, Tier 2, Tier 3. There are your 3 generations. In the middle, you have Carrie Buck. See a little finger pointing, right? Looks so scientific, right? And there's a little F inside her circle. F stood for feeble-minded. Not quite a J, but close enough. Carrie's mother, Emma, also has an F. Why was the mother deemed feeble-minded? I think she had some sort of STD, chlamydia or gonorrhea. Quote me, can't remember which. Never remember which one, but she had some sort of STD that made her promiscuous. So therefore, she's feeble-minded. So there's 1 generation. There's 2 generations. Then you have 3 generations. Vivian, born 1924. This case was from 1927. So this again was a child of the rape between the uncle. And they deemed the child to be an imbecile also at the age of, I think, oh God, I was a few months old. Thank you, 6 months, thank you. So there you have your 3 generations. Grandmother, mother, daughter. 3 generations of imbeciles. Okay. Now, how can you possibly designate a 6-month-old baby to be an imbecile? This is the craziest part. There was a book written called Imbecile. I encourage you to read it, published about a year ago. I'm not even joking. This was the IQ test they gave to the little girl. They took a little coin, kind of like this, right? And they moved in front of her eye, creating a glare. And the nurse said, she's not moving her eye in response to the thing, therefore she's feeble-minded. I'm not joking you. That was it. That was the extent of the investigation. That was it. She was 6 months old. As it turned out, the daughter was actually quite bright. I actually found a copy of her report card. Turned out to yeah. This is Carrie Buck. I'm sorry. This is the Vivian Buck, the little girl. But I actually found a copy of her report card. She has a solid B student. So the little coin test apparently wasn't that indicative. She actually died at the age of 8 due to some sort of intestinal disease. But we'll get back to that later. But this sort of science, right? I'll go back to the family tree. This was considered, accepted, credible science. This was considered a part of, the leading intelligentsia of the day. The same people who wanted to ban the teaching of German and to ban Catholic schools also wanted to impose these sorts of laws. This was progressivism, and I'm editorializing more than I should. But this was one part of the same. It was how to use the power of the state to improve our society. Whether it was by coercing people to teach languages, or coercing people not to go to public school, Catholic school, or even taking out their fallopian tubes. Right? This was the belief. And the notion was the Constitution merely got in the way because these old fuddy-duddy conservative judges. These teachings, which I played Sergio's clip before if you couldn't hear it, were impressive to the Nazis. And the Nazis more or less modeled their eugenics program after the laws in Virginia. And actually, I read something else recently. There's a book out that said the Nazis also copied Jim Crow techniques of how to have segregation. So they got a lot of stuff from us, right? They got a lot of stuff from here. Jim Crow, eugenics, they got them all. Yeah.
So was Joseph Holmes around to see to reap what he sowed when he saw Nazis come to power, or was he gone by now?
He died, check the year, 35 or 34. Someone check the year, I don't remember. But I would suspect he would have been okay with that. 35? Oh, good, yeah.
Yeah, there was like Nazi propaganda that said that a picture of two people and said we're not alone, and they had to show all the countries, they showed the United States, they showed Denmark, they showed Japan.
With the eugenics style programs. Yeah, so I mean, it's very easy to go Godwin's law and say, wow, the Nazis are really, well, they got it from somewhere. And that's the point that this lawyer was trying to prove, that, look, they're doing what the United States had already done. Sergio?
Little fun fact that
It's not really a fun fact, but you can give it
the
fact.
actor who
Oh,
played the
okay, fine.
German defense attorney, he won an Academy Award for that performance.
It was very good. Very good. In any event, so here actually the Dr. Laughlin who came up with this, in 1936, he went 1935, in 36, he got an honorary degree from the University of Heidelberg for the science of racial cleansing. This was 36, right? This is already when things were moving. And I guess Sergio mentioned propaganda. I got propaganda. This says, it's hard to read. It says, some people are born to be a burden on the rest. Learn about heredity. You can help correct these conditions. These were posters that put up in various public places. There's another piece of propaganda. It says, eugenics is a self-direction of human evolution. Like a tree, eugenics draws its material from many sources and organizes them to a harmonious entity. I think I got one more. I don't know, just Holmes. Okay. So this was, again, a very well established norm, this new idea of eugenics.
How well versed were the justices in eugenics? I know you mentioned how they had to do that.
Holmes knew much about it.
So they were.
Holmes was, I mean, so one of the things about Holmes, and this is why, again, I'm not a fan, he actually said he enjoyed writing this opinion. He wrote a letter saying that this was a very easy opinion to write. If you check the dates when it was argued and decided, I think maybe a week or two last. This was he wrote this like in one sitting. He actually, I won't say subscribed to them, but he didn't oppose these ideas. I don't want to try to endorse them, but he was not uncomfortable with these ideas at all. All right. This case also teaches very directly the difference between process and substance, right? So where am I? Charles, let's talk actually about the law itself, how it operated. Give me the process that was given to Carrie Buck.
Well, I was a little bit confused with that. So in the beginning, it kind of implied that the gentleman you showed earlier made the decision at his own will, but then later it says that there's a board that refused.
Yeah, no, you're exactly right. So walk me through the process. You're exactly right. You're not confused at all.
So when he believes that there's someone who might need this, then Sua Sponte brings the issue up.
Yeah, brings her to the colony.
With the colony, okay. And then the colony decides, but it seems like it's a lot on his, that he has a lot of discretion and say in what happens. And so he brings it to the colony decides yes or no.
Everything okay? What's going on? All right, I'm sorry to interrupt. I heard too much chatter. Just one at a time, please. Yeah, go ahead, please, Charles.
And so at that point, it's pretty much in the board's hands, and there's really not a whole lot of extra processes there to do that.
Okay, very good. So what they tried to do here was make something that procedurally was fair, right? So you start off, the superintendent basically says, look, I have evidence to show that she's an imbecile. What's the evidence? Remember the little family tree I showed you a minute ago? That was his evidence. That was an actual exhibit from the trial. That was the evidence. And he had some witnesses testify. I think they actually had some notice saying that from, God, was it Carrie Buck's high school teacher saying that she was flirtatious in class and she was flirt with boys. That was some of the evidence also. Go read this book called Imbeciles. It's a good book, but it's not easy to read. So after the superintendent makes his petition, there's a guardian appointed, there's a lawyer appointed. Again, the lawyer worked for the colony. They submit evidence in writing, this flow chart. If they make the determination that it's in the best interest of society to sterilize her, should we sterilize her? Right? That's it. If this is in the best interest of society, that's an easy standard to meet. After that, you can appeal to the circuit court, which is like the trial court in Virginia. Then you appeal to the Virginia Supreme Court of Appeals. Okay, and after that, I guess you go up to the Supreme Court. So, Alex, is there anything? I'm sorry, AJ. Sorry, I skipped over one. AJ, is there anything procedurally deficient about this regime?
No, they actually said procedurally applications.
Yeah, she's given a lawyer, at least on paper. She wasn't, it was a fake lawyer, but she had at least on paper and a lawyer. She gets appealed to this court, that court, right? So what then is the problem with this law if it's procedurally fair?
They said the attack is not on the procedure, but on the substance.
Exactly. This is an attack to the substance, right? The law basically says, if this guy, right, determines that it's in the best interest of society to sterilize her, then she'll be sterilized. I gave you an example a week ago that if you draw a number of a hat and you get stoned to death, right? A couple of you said that was fine, right? This is what I was thinking of, right? What does it mean if it's in the best interest of society, based on what this guy thinks, that will now sterilize you and take out your tubes? Guys too, this is not just ladies. Indeed, men were actually considered worse because they were considered more promiscuous, that you have these imbeciles impregnating many women, whereas only one woman can get pregnant. So there's actually, men got this treatment as well with vasectomy. The attack was in the substance of the law, right? The attack was to the idea that you could do this. Now, Jason?
Oh, sorry. I was just going to ask, how far does the definition stretch for imbecile at this point?
Oh my God.
When
Everything.
I was thinking about
It does not mean people with mental handicaps. That does not what it means.
Mhm.
Carrie Buck graduated high school. She may not have graduated, but she actually went to high school. She at least had like an 8th grade education. She was in no sense an imbecile. She could read and write letters. There are letters from her, right? She could write. I read them. In fact, I forgot to mention this. The worst part was when they initially wanted to do this, they told her, oh, Carrie, you have some lower back pain. We need to do some surgery on your back to relieve some pressure. Or no, hips, I'm sorry. You're having some pressure in your hips, and we need to do surgery to relieve the pressure on your hips. They tried to just, dupe her. Right? Anyways, but procedurally, they say the court says this is just fine. Just fine, just fine. The attack from Carrie, and again, it's not entirely clear if she knew what was going on. She didn't go, no one really told her what was going on. Her mother was wherever. She was living in this colony. It's not clear what she knew. She knew she couldn't see her daughter. Her biggest thing was she wanted to see her daughter, and they took her daughter away from her because she was an imbecile. That's what mattered to her most. They see her daughter, and she couldn't even see her daughter. But the law itself is what they were challenging. Now, now Alex is up. Why? Now, this is crazy, right? Alex, if the colony chose, could they have, instead of sterilizing her, kept her in this prison forever? Okay, right? Which, for the state, is a better option? Snip, snip, or life lockup?
Oh, the snip.
That was their argument. Right? Probably the shortest answer of the year, right? That was their argument. The argument was that it's actually cheaper for the state to perform a sterilization procedure than to have to lock her up forever. And remember that bit that Holmes says that, the greater sacrifice? If they can lock her up indefinitely for insanity and imbecility, why can't they do the far less intrusive measure of sterilizing her where she can go out to the public and cause no harm? Why? Because she cannot reproduce.
I was just gonna say, I mean, is it really cheaper if they're gonna keep her in a mental institution in the first place? And if she's already a burden on the state.
Just execute her. Well, that's cruel, right? But you're on the right track.
I mean, they make the same argument with death penalty cases too, but I mean, death row inmates sit on
30,
death row
40 years.
for, yeah.
Yeah. But the argument they actually advance is we need to do this as a cost-saving measure. That we have a state police power to rid our streets of these imbeciles, these promiscuous women who are going to, where were you? I was singing your praises. Go watch the video. You'll blush. Filled milk, you'll watch it later. Okay,
My
fine.
rebuttal to your email will come tonight.
Oh, wait, your rebuttal?
Yes.
Okay. Fair enough. Maybe I should withdraw my. No. By the way, never reply all to any emails. You learned your lesson this semester already. Never reply all. I never do it. Okay. I sung your praises. I can withdraw them later.
Thank you.
Anyway, I forget where I was. See, this is why I don't people coming late. They distract me. The state's argument was that this was a cost-saving measure. That would be cheaper to simply conduct this surgery rather than to have to keep them in this colony forever. Of course, the first threshold is, why the hell are you putting them in this colony? They pose no risk to anyone. This is entirely arbitrary procedure. But the court does not. Again, this was within a couple years of Meyer and Pierce, right? The court was willing to entertain challenges to these German teaching laws and these, what do you call them? Schooling laws. But for Carrie Buck, she got 1 vote. So all the judges who not even 3 or 4 years earlier ruled for Meyer and Pierce, McReynolds and the crew, they went along with this one. Let me walk you through Holmes's opinion because it's so short. You can basically read the entire thing in a couple minutes. It'll probably take you 10 minutes to read. And this is the passage that was read in the movie that Sergio sent a few minutes ago. He says, "We have seen that the public welfare may call upon the best citizens for their lives." He's talking about the draft. And the argument is, and again, this is actually not, I'm going to blow your minds in a minute, right? But wait for it. Oh, Josh, perfect for you. If the state can call on people to go to the draft and die, call people to the draft to go to war and be slaughtered overseas, and we just had a world war, so people knew about this. Holmes was a Civil War veteran. He knew about the draft. Josh, if the state can call on someone to go to the draft and be killed, how is this any different? Why is this not a much lesser burden? She can go up and live her life. She simply can't reproduce. What's the difference here?
Difference in the two?
Yeah, why? Why? Tell me.
The draft's random. This is specifically something that.
What if there was a massive conflict, Josh, and it wasn't a random draft? It was all able-bodied males have to go. There was no draft. Every able-bodied man get a gun and go. There's no randomness. So get rid of the randomness.
There is a constitution that allows for not the draft, but allows for Congress to specifically allow.
States have police powers. What do you think? How can it be that the state can take lives, send men overseas to die in the draft, but this far smaller intrusion? I mean, between dying in the trench in Normandy versus having your vasectomy. I mean, I know I would take that like either, but you know, how can it be right?
I think there's no randomness in the state of the draft. In this case, it only applies to inmates.
It only applies. Well, okay. Well, what difference does that make? Doesn't apply to the general population, right? But what if it applies to the general? Let's make the example here, right? That the state would administer a test to every U.S. citizen, right? And if they deem you're feeble-minded, they'll sterilize. Same thing with the draft. Every able-bodied person, you got to pick up a gun and go.
I'm guessing they don't want imbeciles
Okay. What do you think? I mean, how do we distinguish the draft? Beginning with the randomness, right? Figure out the randomness, right? If the state can call people to die, why can't they call them to a much smaller sacrifice of sterilization?
I missed some of the history.
Well, make an argument, right? Why would this be different? Make an argument. Yeah. Holmes says it will be strange if the state cannot call upon those who sap the strength of the state for a lesser sacrifice. For a lesser sacrifice. It's a far smaller sacrifice. Why? So do you think that this decision is justifiable? If you think it's okay that they can call on the greater sacrifice for war as call on the lesser sacrifice for civilization, is this justifiable? Is Holmes right, maybe? Maybe his language is also, but is Holmes right?
I think it just depends on the end goal. Like, war is, well, I think like when you have something like drafting people to go to war, like that's just a for our society. And
As was this.
Right, but I think that it's really not like necessary overall to preserve like the entire society. Like you can preserve.
How do you know?
Well, I mean, I don't know, but I think there are more rational people than there are in the South walking around. So I believe
in this class, at least.
When you go to war, imagine like talking about people who are evil-minded. Very
This is a weird argument, but didn't they get paid to be drafted? Did you get paid still?
I'm sure you got paid.
So they don't pay you to get paid.
Maybe they give her a consolation prize. I don't know. Yeah, Jay.
Could you say that it's because of it's like compelling governmental interest standard?
And this, I think, is Chandra's argument, right? That war is far more important than. But how do you know that? What if, in fact, the greatest existential threat to society was imbeciles walking around? Right? You're all using your 20/20 glasses. You didn't know what the science was back then. Someone else is booking here. Yeah, sure, why not? Go for it. Says who? The threat our society faces are imbeciles. We need to root this out of our society.
There are other ways
Bottom up. Forever.
Draft part of the war, which inherently means that the nation's liberty of all is at threat.
Our genetic gene pool is at stake. People who were believing we've run out of food, right? These were the people thought we run out of food, that the world would run out of supply. We can't sustain this population growth. Malthusians, thank you so much.
It's comparing the jeopardy of the viability of the entire nation to a situation of economic convenience of the states.
You're second guessing their end goals, right?
I am.
You are. Anyone who's not second guessing their goals won't give an answer. Cameron, you're hesitating.
So the draft is the form that we described is a uniform application. Everyone, irrespective of any background. Whereas this case, there is a discrimination on the basis of the mental faculties of the person.
Isn't this even better? We don't have to sterilize everyone, just the imbeciles. This is even better. It's more narrowly tailored.
We have gone through those basis of purifying the genes and purifying the races.
Yeah, but you're second guessing their motives, right? Why is Holmes wrong? None of you have given me a good reason yet. I told you I'd blow your minds. Nico.
This might be a little cheeky, but getting sent to war isn't necessarily a death sentence. Probability is high, but you still have the chance to fight for your life. Whereas if you're just automatically pulled with that, snip.
Well, she's not automatically. She gets to go to trial. Maybe the trial ruled the other way.
Right, but it's not like a trial like combat where she has like this fighting chance of you doing.
Say that I think this is all like in reference to the time period, because back in like those, I think we just got out of the First World War, so being in the military was kind of like what everybody wanted to do. If you were a veteran, everybody was proud of that. Where you're not exactly proud of your feeble-minded, son or daughter taken care of. And then of course it's different now. Like we treat, our feeble-minded people nowadays much better than they got to back then. So.
I'm still not persuaded. You guys still haven't persuaded me.
Who is Justice Holmes to say that
Who
the
is?
sacrifice of not being able to continue your genetic output is greater than dying? Because isn't like every living organism, their sole goal is to reproduce?
But these are parasites in our gene pool. We got rid of them. Got rid of them. Gotta get rid of them.
They're parasites to those who aren't them though. Like
Brian?
Is different because what he's talking about is based on something that's like hereditary, and whereas with the draft, it's not. It's just.
All right. I think you're all in the more or less the same wavelength. Let me ask another question, right? All right, Samantha, let me ask you this question. Can the government force you? Can the government force you to get vaccinated? If you refuse to take a vaccine, what does Holmes say about vaccination? Very end. Yeah. I loud. I couldn't hear. I'm sorry. So the government has to take a needle and shove it in your arm and put in this weakened strain of vaccine. By the way, this is not anti-vaxxer stuff. Please, in the early 1900s, vaccinations were actually lethal in many cases. They would kill you. Right? This is not like Jenny McCarthy stuff, okay? Vaccinate your children. Not even gonna ask, right? So Samantha, why is vaccinations any different than sterilization? I mean, if the state has an interest in preventing an outbreak of a disease, they can jam a finger on it. If they want to prevent an outbreak of feeble-minded people repopulating, they can take whatever measures necessary. You know what? I think this policy is being generous. Virginia can just sterilize everyone. Have a lottery and sterilize people that way. Would that be more fair? Like a draft. You have a draft lottery, you have a sterilization lottery. This is actually more narrowly tailored. You're only sterilizing those people who have designated signs of feeble-mindedness with this esteemed doctor reviewing it. Right? What do you think? Right? How do we draw this line between letting people go to the draft, letting people get sterilized? I mean, Holmes writes. Where's the line? The principle that sustains compulsory vaccination is broad enough to cover cutting the fallopian tubes. So I said a case called Jackson v. Massachusetts, written by Justice Harlan. A man, right? Isaac, what do we do here?
I think that the principle that he's citing is that one of the three people who should have a decision of what they do about themselves. Such a due process hasn't really been brought into play at this point. The idea that there's some freedom or responsibility and being a human being or something that we really thought about.
You said abhorrent to the human race, right? Human people and fundamental rights. You're doing what McReynolds did. You're saying, here are these rights I think are really important. No?
No, it's true.
Where do you get this from? I don't know. Where's this written down?
It's from the Lord.
The Lord. Did the Lord say thou shalt not sterilize? Where?
There are Hebrew principles at play here.
Hebrew principles? Yeah. You're all giving me the runaround, right? If Holmes' this opinion is so awful, why can't any of you rebut it? Right? If Holmes' opinion is awful, how do we know then what liberty is? How do we actually know what liberty is, right? Hold on, people. I'm gonna talk a little bit. Right? So the reason why this discussion is I'm dragging it on is it goes back to the single point. You're saying that the Virginia scientist is an idiot, and that he's wrong, and that Carrie Buck is not feeble-minded. I'm with you. She was fine. She was educated. She could write. There's no reason in the world why you'd ever want to sterilize her. But each of you took from your starting point that the word liberty in the Due Process Clause gave courts the license to stop that. This was a duly enacted law by Virginia. Right? No different than the compulsory vaccination law from Massachusetts. If you're put your hand down, it's fine. We're moving, right? So if the state has this police power, then the court needs to look at the word liberty and make a decision of what that word embraces. And I spent so much time on Justice McReynolds at the outset because he just pulled these things out of history, right? So maybe the answer is, and I don't know, the answer is, wow, the government has never before tried to sterilize people. Shucks, this is new. Maybe this violates a long-standing principle that we have in our society, right? Maybe the reason why this was so egregious was because it had never been done before. In fact, probably science didn't exist to allow it to be done. You couldn't safely sterilize a person without killing them due to infection and sepsis and whatever else. But what Holmes is saying is we should not stand in the way of progress. And if these sort of newfangled rights, right, these newfangled scientific techniques won't improve our society, who am I to second guess the government? So this is the notion of deference, right? All of you are very much willing to second guess the effectiveness of this sterilization program. The court, vote 8-1, was not. They say, we're not here. You say, well, of course, an invading army that you need to draft for is different than sterilization. Well, they'll say, our gene pool is being invaded, and we need to enlist every person. And by the way, he kept saying, well, it wasn't random. One of the arguments Virginia adduced is, we're not doing this for everyone. We're only doing this to those we deem feeble-minded. This is narrow tailoring, right? This isn't core motto where everyone's getting locked up. It's only those that go through a trial. This is actually a fairly specific thing, right? The specificity helps it, not hurts it, in terms of constitutional scrutiny. If they simply sterilize everyone, that would not be narrowly tailored, but this is. So you see, the difficulty of this case, and again, as a policy matter, people say it's insane, is how do you decide how much scrutiny you're going to give to a state law? I'll mention one final note about Buck v. Dell before I move on. This case has been subsequently cited by the Supreme Court. You won't see it because it was edited out of your book, but I'll make sure it's there for the next edition. In Roe v. Wade. And so follow me here, right? The idea of Buck is the state can impose various conditions on people with respect to their health, right? They think they're imbeciles, they can sterilize them. The part of Roe v. Wade which said that after a certain point, the state can prohibit abortion, in other words, forcing women to carry the child to term, they cite Buck v. Bell for that. They say that the state has an interest in your health. You don't see it in your book, but it's in there. What happened to Carrie Buck afterwards? She was indeed sterilized. She was saying, as it was happening, something like, this is not right, this is not right. The only dissent was by Justice Butler, who was the only Catholic justice, and there's suspicions that his Catholic teachings perhaps made him opposed to this. In fact, the Catholic Church at the time was the biggest opponent of sterilization. Okay, now.
I just wanted to ask, so I don't understand how he can draw the line between serving in the military, which is only a potential loss of liberty, versus this is an absolute loss.
I think Nico said that, yeah.
Right, which is an absolute loss of
I think that's a valid response. I think it's a valid response. But I think if your general wants to send you on a suicide mission, you go on that mission. If you're in the military and your general says, we're gonna put you on the front line, you're not coming home tonight, you have to go to the country.
You don't have to do it.
Get shot. Anyone in the military here? Dustin's not here. Yeah, if you disobey orders, you're shot. So either you get shot or you get shot.
Sorry, I'm not thinking of the time period. Okay.
Yeah. I mean, if you disobey orders, you're in trouble. Dustin will tell you later, I think. But yeah, Javier.
If Congress had passed this like a law similar to this, could they have gone away with like the power of general welfare to sterilize people?
Well, there's no article on power of general welfare that's a spending power.
Right, but, it makes some constitution to eventually lead up to sterilization. In the same format, I guess. Like
I don't think that's a regulation of commerce, but under Wickard it probably is, because Carrie Buck may spend some money somewhere, and that would be a regulation of commerce. I'm being mostly facetious, but yeah. Her decision to be sterilized has substantial effect in interstate commerce because she's not buying diapers. I don't know. They'll think of something, some hook. I'm being cold deliberately because the answer is probably yeah. Eugenic laws were in effect for the 1960s and 70s in the United States. This did not go away anytime soon. And this precedent not only cited in Nuremberg, but elsewhere to uphold this practice. You even have this today in a modified form where sex offenders are often given the choice of more jail time or sterilization to get out early. They do what's called chemical castration now. So you don't have to do surgery. Basically, they give you something to drink, and yeah. All right. Any other questions about Buffy Bell? Uplifting discussion, huh? Go.
With what you were just talking about, that's a choice, though, at that point.
It is.
So,
Laura?
It's like not, can you explain the chemical?
I actually know how it works. Google it. Google chemical castration. I actually don't know exactly how it works, but Google it and you can tell me later. Yeah, last question.
I was just saying, I Googled it.
Oh, tell her.
I don't remember everything, but it's not like as definite as it sounds. In fact, it's mostly like an extreme lowering of the sex drive when the person doesn't want to have sex, or in the case of like a male, can physically have sex. It'd be like ED.
This way, Lauren. This way. This way. Yeah, that's okay.
That's enough.
Yeah, okay, that's enough. Thank you. So let's talk about birth control now, right? We're hitting all the sexual functions today, right? Okay. So let's go back to Griswold. We have a half hour left. We'll get it in, I promise. So Griswold, 1965, was a challenge to Connecticut's contraceptives law. And as it's noted in the dissent by Justice Stewart, this law is basically never enforced. It was never enforced. It was on the books, but it was never enforced. And this is Estelle Griswold, who was the lead plaintiff at the Planned Parenthood Center in New Haven, Connecticut, right near Yale University. And this case was designed as a test case. Where's the picture? I have it somewhere. Once again, you can see them getting arrested here. Why was there a photographer there at the time of their arrest? Was this a surprise raid? No, they wanted to get arrested. They were openly violating this law to get the test case up. They wanted to test the constitutionality of the law, the use and the distribution of contraceptives. So let's see. Gladys, as a threshold matter, but it's not too crassly. Was this about Ms. Griswold using birth control? No, it was not about Ms. Griswold using birth control. What was this case actually about? Why was she the plaintiff, or actually defendant, I should say? I know, but what interest was Griswold herself asserting? What was her interest in this case? She wasn't using the birth control herself. What interest was she asserting? Who was she giving it to? Who would a doctor give birth control to? But not just any women. What kind of women? Not sexually active, I heard you. No. What kind of sexually active women? Married, thank you. Yes, so you're indeed no book or anything else. Right? Look at that. He's just sitting there, right? He's trying to prove me wrong, Larry. He's typing his email blackens off, right? This was a case where Griswold and another doctor, guy named Buxton, were providing counseling to married women, and the married part was very important, right? This was not about unmarried women. They gave it to married women, and they gave them birth control products and counseling of how to use it, right? This, the statute prohibited. It gave a fine of $100, right? So one threshold issue in this case is Griswold wasn't asserting her own right to use contraceptives, right? The cops didn't raid someone's bedroom. She was asserting the right of her patients to use these products. Thank you, Siri. Heard that. Okay, she was asserting the right of her patients to use these products, and the court found standing. Okay, so Alexa, at the very beginning, Justice Douglas is again Justice William O. Douglas, who was the he was a Roosevelt. Do I have a picture from up there? Who was a Roosevelt appointee, and he discusses Lochner, right? So Alexa, how does he try to separate this case from Lochner, the boogeyman, which Justice Breyer scared at night? Yes. Why is that a difference? Don't you have a right of contract? Well, if you have a contract, why is it any different? You're right. You're exactly right. You're giving me the correct answer. But what's the difference between a liberty of contract and a liberty of privacy between husband and wife? Good. But why is it different from Amund Schmitter's right to work 80 hours a week in the bake shop? Okay. I just don't know how to add pop on my computer. It's happening class before. It's okay. I don't know. Colin, what do you think? Why is Amund Schmitter's liberty interest in working 80 hours a week in the bakery to support his family any different from a couple's right to use birth control to, I guess, control their family?
Well, there's no specific clause in the Bill of Rights that they have just kind of created, to privacy in regards to contraceptives.
Is there a clause for either contract or contraceptives? So then how do we distinguish these two? Papa, take a step?
Well, they said that the marriage was sacred.
Yeah, where do we get that from? Yeah, where do we get that from? What case? Jeffa? Which one's expressed and which is implied? Where's contract expressed? How do we distinguish Amund Schmitter's right to work 80 hours a week from married couples' right to get birth control? Why is one right different than the other? Neither stated. I think both are implied. Both are parts of the liberty component of the 14th Amendment. No, Stephanie? The Constitution implies the right of privacy, but it does not imply a right of contract. Is that your argument? That's Douglas's argument, right? That's what Douglas says. Douglas says, look, the right of privacy is not some sort of free-floating right in the 14th Amendment. We're in footnote 4 of Caroline Products here, right? The right of privacy is in the Bill of Rights. This gave rise to perhaps one of the most, I'll say it, nonsensical passages in the history of the Supreme Court. I'm going to read it to you, and to read it is to laugh. I'm sorry. This is what passed for constitutional law in the 1960s. The foregoing cases suggest that specific guarantees in the Bill of Rights have penumbras, emanations from those guarantees that help give them life and substance. Renew. You ever take astronomy? Anyone ever take astronomy? Anyone know what the hell an emanation and penumbra is? Grant, what the hell is an emanation and penumbra? What?
I know penumbra is the black spot on the outside of solar.
Yeah, I love this case because I can teach astronomy. John, you know? Chandra, you know? Anyone? Yeah, okay, so this is what passed for constitutional law in the 1960s, right? So here's your astronomy lesson for the day, right? This is the sun. This is the earth, right? Why do we have night and day, right? The earth spins around. But also, the earth rotates, right? Goes around the sun, orbits. At various points, the earth gets in the way of the sun. And it blocks light from going on to the sun. And the reason why we have night is there's no light here. And it casts this shadow on the moon, right? But it's not the complete shadow because some of the light bounces off the shadow. So I think what Douglas is getting at, he actually stole this from an article, if you can imagine, someone else wrote this first, is that even though the actual text of the Bill of Rights doesn't suggest a right of privacy by itself, there are beams of light emanating from the Bill of Rights. I've been staring at this thing all day. It hasn't lit up yet. I'm waiting for it to light up and go shoom, right? Oh, abortion, there it is, right? But I'm waiting. It'll happen eventually. But the idea is that the text of the Constitution is where we get this from. He rejects the notion that this is based on the 14th Amendment. He rejects that notion. Why? Again, to distinguish this from Lochner. He says this is not Lochner. We are on footnote 4 of Caroline Product. We are reading the Bill of Rights. And because this right of privacy in the Bill of Rights, we can give it strict scrutiny. That's the basis, right? So Zishan, what are the various provisions of the Bill of Rights that he finds as the basis for this right of privacy? First Amendment, yeah. What's in the First Amendment? What does he say? He says it. Chris? Yeah. So we have the right of assembly in the First Amendment, right? So Chris, how does the right of assembly get us to birth control? Assemble where? In the bedroom? Okay, cohabitate, is that what assembly means? Get together? I mean, how do you get from the right of assembly to a right of contraception? Cameron, what about the Third Amendment? We don't mention the Third Amendment very much. What does Justice Douglas say about the Third Amendment?
That refers to during, other than the war times, the soldiers cannot stay.
Yeah. So what's the connection between that and privacy?
The idea is that the home is a private place where people are independent.
Okay. Very good. Notice he skips the Second Amendment. He glossed over that one. Bernardo, let's talk about the Fourth Amendment, right? This is probably the best one. What's the relation between the Fourth Amendment and privacy? What do we got?
He affirms that the right of the people that they can be secure in their home in their presence without a reasonable search.
So the cops can only come in with a warrant, right? Yeah. Grant, what about the Fifth Amendment? What's in there?
It says the self-incrimination.
The zone of privacy, right? Mm-hmm. Yeah. And then he skips 6, 7, and 8, and then we get to the Ninth Amendment, right? Right. Grant, what's the Ninth Amendment? Just finish it up. What does he say about the Ninth Amendment?
It's the enumeration of the Constitution. Certain rights shall not be construed to deny or disparage others retained.
Okay, so you see what he's doing here. He's reading very selectively the various provisions of the Bill of Rights to say this creates a general norm of privacy, right? This vaunted right of privacy. If any of you watched the Gorsuch hearings last week before, they kept saying, "Do you agree with Griswold? Do you agree with Griswold?" I was like, of course. If anyone ever read it, you realize it's an insane opinion. This is not. The concurring opinions, I think, are far better. They actually attempt to be serious. This is not meant to be serious. It's not. It's not. The concurring opinions, I actually have respect for this one. I don't say this often, but it's a joke. So he says, this case then concerns a relationship lying within the zone of privacy. Right? So he reads the entire Bill of Rights, not any one provision, but all these amendments in sequence. this law cannot stand, right? Because it's regulating an area that the government cannot reach, the marital bedroom. And he puts a lot of focus on this. Justice Douglas was, I think, thrice or 4 times divorced. He married a couple of his secretaries. Very interesting guy. This is one other reason I can't respect it. The irony coming from him is even worse. Like, he would marry a secretary, leave his wife, and like a decade later marry the next secretary. It was a check on the dates, but that's more or less the pattern. Krista.
So this would have probably been ruled a different way if it had been a married woman.
Well, you'll do another case next week called Eisenstadt v. Baird, which involved unmarried couples. And all this hocus pocus about marriage, they get rid of it next week. Say, well, it's a violation of equal protection to treat married and unmarried alike. This was all fake. Right? This was just a way station to abortion. Right? This opinion wasn't meant. This was like the next step in the road. This is where they were going with it. Right? Sorry, I can't take this opinion seriously. It's there. So the sanctity of marriage, yada yada yada. Its association promotes way of life, and is unconstitutional. There's not much more to say about Douglas than that. That's it. Let's talk about Goldberg. I expect a lot of you like resonate with Goldberg, right? Yeah, people. Because when I took this case in law school, I was like, yeah, Goldberg, right? So one bit about Goldberg to begin. We don't study the Ninth Amendment much. I wish we had more time for it. And this is perhaps one of the most thorough treatments of the Ninth Amendment in Supreme Court case law. The Ninth Amendment does not apply to the states. Whoa. Right? Rights. It applies to Congress. There's never been any argument that we should incorporate the Ninth Amendment. A couple of judges actually tried to, but never went anywhere. So, as much as I love Justice Goldberg's analysis, it's not real because he's not actually applying the Ninth Amendment to the states. What he's saying instead is that we should use the Ninth Amendment as a guide to interpret our rights. And I think this is actually the strongest point in the entire opinion. Right? That the mere fact that rights are unenumerated does not mean that we should deny them effect. And I think this is the basis for substantive due process, that the mere fact that we don't have rights written down does not mean we can't ignore them. He's not Holmes, right? Holmes said, if it's not written down, we ignore it. Goldberg's saying, no. Read the Ninth Amendment as a guide, and unenumerated rights can be protected. Okay? And then Justice Goldberg actually tries to give a basis for how to decide what rights are unenumerated. So I asked all of you at the beginning about Justice McReynolds. Where do you get this from? And what do you say? Long-standing rules, right? Long-standing norms. What does Goldberg say? We look to, quote, traditions. Tradition, right? We look to traditions and collective conscience of our people to determine where a principle is, quote, so rooted as to be ranked as fundamental. That's what I was talking about before. That's what McReynolds said, right? It's not pulling things out of the penumbras of the sky, like Douglas said. It's you look through traditions and history and custom. So judges can at least try to reach for something when they're protecting these rights. Of course, that raises the question, would contraceptives in 1965 be part of that tradition? Probably not. It was still illegal in many states. The technology was fairly novel, hadn't been around that. I mean, you always had some sort of contraceptive, but the idea of it being available in a drugstore is a fairly novel idea. Would birth control be so deeply rooted at 1965? Maybe yes, maybe no. If it's a close question, do you defer to the courts or defer to the legislature to decide to maybe repeal this uncommonly silly law? So I think that's perhaps the biggest weakness in Goldberg's opinion, but he actually takes a responsible approach to constitutional law, unlike Douglas, and tries to find some framework to decide whether these rights should be incorporated. Okay, then we have Justice Harlan, and this is, by the way, the grandson. First, they were related. And it's a pretty good family, if you ask me. And Justice Harlan says, no, we don't need the Ninth Amendment. The 14th Amendment by itself gives us this answer. This is the Liberty Clause. And he thinks the 14th Amendment would protect this by itself. Okay. Justice White, right, Wizard White, he was the one from Gorsuch clerked, gives an intellectually honest answer. He says, look, this is not Lochner, right? Why? Because Lochner is about economic arrangements, and this is about family and basic civil rights. So he draws a distinction saying economic here and family interest there. Why is that the distinction? Because he said so. But he at least, again, tries to draw a distinction. He into the room, which is Lochner. Douglas just pretends it doesn't exist. Let me move on to the dissents. Justice Black and Justice Stewart. Justice Black says, we should not base our decisions on what is wise law. The Constitution has no right of privacy. Certainly, if you have a criminal investigation, you need a warrant to investigate. That's privacy. If the government wants to send troops to your home, that's privacy. But we're talking here not about privacy from the government, but they're saying privacy in your own bedroom, do as you wish. That's something different than what the Bill of Rights is concerned with. Because as this picture shows, this wasn't about using contraceptives in your bedroom. It was about buying them and going out to your local Planned Parenthood store and getting them. Right? This was a public act. Perhaps the contraceptives will be used privately. Keep in mind when we do the abortion cases, are abortions performed privately? It's a fairly, other people involved. It's not exactly done in the bedroom. A Black also says we should only strike these laws down if they're arbitrary and capricious, if they make no sense. This law, he says, we may not agree with, but it's not arbitrary and capricious. Black also criticizes the majority for recasting Meyer and Pierce as First Amendment cases. They weren't. He says, look, Meyer and Pierce are Lochner cases. They're substantive due process cases. And drop this charade about the emanations and penumbras and be honest about what you're doing. He also makes the point that I thought in Williamson v. Lee Optical, we abandoned this idea of using substantive due process, bringing it back. Justice Stewart had a fairly brief dissent. It's a famous line. He calls this law uncommonly silly. And when you read Lawrence v. Texas, the Texas sodomy case, Justice Thomas quotes from this. And Justice Thomas made a similar point about the sodomy statutes, that this is a silly law. And if I were a member of the Texas legislature, I would vote to repeal it. That's different from the question of what courts ought to do. And Justice Stewart would also have upheld it. Okay. But again, Griswold, you have to understand this case. This wasn't meant to be important by itself. It was a stepping stone in the path. It represented a break with footnote 4 and a break from Williamson v. Lee Optical, saying, okay, courts, we're back in the business of scrutinizing social legislation, but only if it's of a social nature, not for economic stuff. So it'll be, ignored. But if it's a fundamental right we deem for social family rights and planning rights, etc., we'll give it scrutiny. But more importantly, Griswold was the beginning of the step towards the rights for abortion and the Roe v. Wade case about 7 or 8 years later. This is merely starting that process. Okay, questions on Griswold? Sorry, I went a little bit quicker than I wanted. Our Buck discussion took longer than I expected, but it was worthwhile. I haven't gotten stoned yet, at least. Actually, the hand? No, okay. Questions on Griswold? Really? Nothing? That what penumbra is? No questions on Griswold? Questions on Goldberg, maybe? Wow. Nothing? It's an important case. Okay, I'll summarize up for the day then, if none of you are interested. The due process clause at its basic level always presents a difficult question for judges. How do you put together that list of rights that are included? The Griswolds took a stab at it. Goldberg took a stab at it. You'll find later that in several cases, Justice Kennedy takes a stab at it. And at bottom, who are we to say that they're right or wrong? Maybe you could say they're wrong because we should be originalists and only recognize those rights that are deeply rooted in our traditions. Or maybe you can say they're correct, that the word liberty was meant to be expansive, that future generations could fill in the blanks. And that's what Justice Kennedy writes. You know, take whatever position you want, but recognize that it is indeed courts that are ascertaining the scopes of these rights, which is inherently anti-majoritarian because the legislature said we're going to restrict this, and the court said, no, we will not, whether it's with birth control, abortion, sodomy, sending your kids to school, or working 80 hours a week. These are decisions where the legislature said we want to regulate for the police power, and the court said, no, you cannot. Anything else? I will see you on the Tuesday.